global happenings today. We communicate, we analyze global news.
Hello, great people. Welcome back to our channel. We're so excited to have you again. 12 PDP states decided to move against Bola Tinubu over the issue of emergency rule and the suspension of elected officers in Rivers State, including the governor, the deputy governor, and the House member. But right now, there's a fresh crisis that is brewing, considering the issue of defection. Don't forget that some are planning to defect while some have defected, and it's almost tearing the whole thing apart. Let's look at full details of what is going on as a fresh crisis has hit the camp of the People Democratic Party PDP governors as Delta State pulls out of the suit that is challenging President Bola Tinubu's declaration of the state of emergency in Rivers State. The development came about 12 days after the governor of Delta State, Sheriff Oborevwori, and the entire leadership of the PDP in the state, they come to the ruling All Progressive Congress APC and pledged their unalloyed support to President Tinubu. Delta State was listed as one of the plaintiffs in the suit marked SC/CV/329/2025, which governors of then 11 PDP states lodged before the Apex Court. The plaintiff specifically challenged President Tinubu's power to suspend democratically elected state officials, including a serving governor and his deputy, and replace them with unelected ones. Aside from Delta, other states behind the suit were Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Taraba, Zamfara, and Bayelsa. The governors had, through their respective attorney general, posed 6 questions for the Supreme Court to determine, among which included whether the President of Nigeria can lawfully suspend or interfere with the offices of the governor and deputy governor and replace them with an unelected appointee under the guise of a state of emergency proclamation. The plaintiff urged the Apex Court to also determine whether the Attorney General Strait, acting on behalf of the President to suspend the offices of governors and deputy governor by virtue of such proclamation, was in contravention of the provision of the 1999 Constitution as amended, as well as principle of constitutional federalism. They further prayed the court to determine whether the National Assembly could approve a state of emergency proclamation, including suspension of state executive and legislature by a simple voice vote rather than the constitutionally required two-thirds majority of all members of each chambers. Upon determination of the question, the PDP governors, among other reliefs, applied for an order nullifying the state of emergency proclamation in Rivers State as published in Official Gazette number 47 of 2025. They equally prayed for an order of perpetual injunction restraining the defendants from suspending or approving the suspension or in any way interfering with the offices of governors, the deputy governors, and or the House of Assembly of any of the plaintiff state by way of proclamation of state of emergency or in any manner whatsoever or by any method howsoever. Cited as first and second defendants in the matter with Attorney General of the Federation and the National Assembly respectively. However, the Supreme Court, through the Chief Justice of Nigeria CG and Justice Kudirat Ekere Ekun, is setting up a 7-man panel that will hear the constitutional matter. The plaintiffs suffered a depletion in their rank, with Delta State withdrawing from the case. A top government official in the state disclosed that the Delta State Governor Oborevwori has already instructed the state legal team led by Attorney General Mr. Ekemejero Oworiole, Senior Advocate of Nigeria, to file notice of discontinuance. According to him, he says, at the moment, Governor Oborevwori is no longer a PDP governor, so there is no basis for him to remain a plaintiff in the suit that was filed by PDP governors. I can assure you that once a date is fixed for the Supreme Court, the Delta State legal team will formally withdraw from the hearing. There are indications that Akwa Ibom State may equally pull out from the suit. Meanwhile, both the AGF Prince Lateef Fagbemi, Senior Advocate of Nigeria, and the National Assembly have queried the competence of the suit and the jurisdiction of the Apex Court to hear it. In his preliminary objection, the NAAS contended that the plaintiffs failed to fulfill the conditional precedent that would empower the Supreme Court to hear the matter, which he described as frivolous and speculative. It was part of the contention of the National Assembly that the plaintiff failed to issue the statutorily required 3 months pre-action notice to its clerk as mandated under Section 21 of the Legislative Houses Power and Privileges Act 2017. It maintained that the Act provided that a person who has a cause of action against the Legislative House should serve a 3 months notice to the House of the Clerk of the Legislative House disclosing the cause of action and relief sought. More so, the NASS argued that the plaintiff did not secure resolution from their respective State House of Assembly, a prerequisite for approaching the Supreme Court under its original jurisdiction provision outlined in the Supreme Court Original Jurisdiction Act 2002. The second defendant accused the PDP governors of attempting to use the Supreme Court to dictate how it would perform its constitutional duties, especially as it relates to the use of voice vote to ratify state of emergency under Section 305 of the 1999 Constitution. In the suit, the plaintiffs seek to use the court to curtail the manner in which the second defendants vote or make approval to ratify proclamation of state of emergency declared pursuant to Section 305 of the CFRA 1999 to get the 2/10 majority of their vote. It also seeks that the court detects how much rules are to be performed by the second defendant. The suit seek to restrain the second defendant from using voice vote to gain majority approval for future or anticipated proclamation of state of emergency in the state of the plaintiffs. The suit also seek by perpetual injunction to restrain the second defendant's house, the Senate House of Assembly, from carrying out their constitutional duties of approval of proclamation of state of emergency and seek that the approval given by the second defendant on the 20th day of March 2025 ratifying the proclamation of state of emergency in Rivers State be set aside for being wrongfully approved. The second defendant or applicant have observed the several deficiencies in the suit of the plaintiff which go contrary to the provision of the law and the jurisdiction of the court, raises objection and submit that the 11 states approached the court wrongly and in abuse of court processes. The NAAS, which filed a memorandum of conditional appearance in the matter, had added. Now, while praying the court, that's the apex court, as Supreme Court, to dismiss the suit as unfounded, frivolous, and a vexatious waste of resources, time, and energy of the second defendant, the NAAS pray for a cost of 1 billion naira to be awarded jointly and severally against the plaintiff. Now, that was their position. If you check our video, you're going to see full details of all of that, where NAAS took a position in terms of objection to the suit. But right now, the drawback is that one of those who were a plaintiff in this suit, talking about Delta State government, have decided to gather its legal team to issue a restriction or a withdrawal from the case. The big question is, how would that affect the case? Those who are legal luminaries can tell us more about that in the comment section. But right now, the other people that's talking about the other governors are still maintaining their position, and we are hopeful that within this month that if similar Fubara is not being recalled back, and also if the right thing is not being done, I think that the Supreme Court will roll out a 7-man committee who will deal with the constitutional issue and will give Nigeria a position, whether it's going to be a new position against the Constitution, because already in the Constitution is provided that there can be state of emergency in event of several conditions, which none of it was in Rivers State. It was the president actually acted preempting that such will happen, because it never happened. There was a prolonged case of political crisis in the state, but there was no case straight to life. There was no issue of maybe war or anything in the state. Now, even if that is justified, we all know that the suspension of an elected governor is outrightly unconstitutional. The big question is, how would Supreme Court defend that if they have to give it the way of give it to the federal government or to Bola Ahmed Tinubu? Well, let's meet in a commission and talk more on this. So, what kind of effect would the withdrawal of Delta State government